Hi everyone, and welcome to our third monthly case study. In today's case study, we'll be looking at a estate administration and some of the proactive steps which the executors took to avoid a family provision claim from being made. So for those of you who aren't aware of what a family provision claim is, briefly, it's an application that an individual person can make to the Supreme Court in the relevant state for a share or a larger share from the estate of a deceased person. And to be able to make that application, you need to be what's called an eligible person. This essentially extends to spouses, de facto partners, former spouses or de facto partners, and also the children of the deceased person. In addition to being an eligible person, they must have either been left out of the deceased person's will entirely, or they feel that perhaps they didn't receive what they should have been entitled to receive from the estate. So in other words, they feel that insufficient provision has been made for them out of the deceased person's estate. So with that in mind, if we jump to the circumstances of this particular case study, here we had a client of ours who passed away in November of last year, and he left behind a de facto partner who he had been together with for over 20 years, and also 3 sons. And in terms of his personal estate, there was one main property which was valued at approximately $5 million. And in addition to that, there were a few different personal effects which he owned, including both private company and public company shares, a motor vehicle, and also some artworks. And altogether, they were valued at approximately $300,000. So the client had prepared and signed a will back in 2014. And under that will, there were a few different gifts. So he had left all of his real property to a bloodline trust, which he had established during his lifetime. And the balance of his estate he had left in different shares to 3 bloodline testamentary trusts, one for each of his sons, and also a share to his de facto partner. However, when it came down to it, only 1/8 of the balance of his estate had been left to his de facto partner. So when we look at the value of the balance, that really only equated to $37,500. So the executors in this situation very quickly realised that this de facto partner would have the ability to make a family provision claim. And if she did decide to bring that application, it was very likely that the court would make an adjustment in her favour. Now, also to keep in mind, we had implemented some estate planning and some asset protection work for this client. So we had advised them that if the de facto partner did decide to bring a family provision claim, that the executors would have very good cause to argue that the deceased net estate really was nominal, and so the court would have nothing, essentially, from which to make an adjustment in her favour. Even with that in mind, the executors were quite commercially minded and also realised that when we're going through the process of litigation, you have that inherent uncertainty, you have the expense in that each of the different beneficiaries need their own legal representation, and you also have the time cost in that these proceedings can drag on for 18 months, 2 years, sometimes even longer. So for those reasons, the executors and beneficiaries decided to enter into a deed of family arrangement, and we were able to assist with the drafting of that document. And essentially, the de facto partner, it was agreed, would receive 1/8 of the entire estate and not just the balance. So that equated to a much more significant sum. It was also agreed that the property would be sold and those proceeds distributed amongst the beneficiaries. And because it was the main residence of the deceased, there would be no tax consequences on that sale. So the end result is that even though the sons were ending up with slightly less money in their pockets at the end of the day, it was a great outcome for everybody involved because they know that they don't have that threat of pending litigation. So certainly this case study demonstrates that it's important to have those estate planning and asset protection mechanisms in place. But at the end of the day, if there is a risk of a family provision claim being made, it may also be worthwhile looking at entering into a deed of family arrangement to avoid those proceedings from being commenced. So thank you all for listening, and I hope that case study was of some assistance to you all. Thank you.